dear Hafsa teacher. I hope you are fine and your health is very good. And also you are not bored during the content. Let's start my presentation. Caves of Steur versus the Netherlands. We have three persons in our case. One of them is Mr. W. Mr. W is Social Security Investigating Officer. And the other person is Mr. B. Mr. B is a person of surname's origin and who was suspected of having unjustly received social security benefits and in this context having committed forgery. And the last person is applicant. The applicant is a Netherlands national and who was born in 1951 and he is a practicing lawyer and was not represented before the court. What is the material element in our case? The Social Security Investigating Officer Mr. W took and recorded a statement from the Mr. B. Because of having committed forgery, Mr. B signed the statement. However, Mr. B was from another origin, so he couldn't understand what the statement exactly about. In addition, Mr. B had not any lawyer or interpreter. So Mr. B prosecuted for social security fraud. What did the applicant say? Here is the applicant's statements and I summed up in order there. To sum up, applicants emphasized that the importance of the statement was not understood by the Mr. B. And Mr. B was under the pressure while his statements was being taken. Mr. W learned that statement which is belonged to applicants, so after that he filed the complaint against the applicant to the dean of the local bar associations because of the applicants tarnished his professional honor and reputation. The dean forwarded Mr. W's complaint to the disciplinary council. However, disciplinary council rejected as unfounded the complaint that the applicant had also accused Mr. W of perjury. After these circumstances, the applicant rejected, so the applicant sought an appeal with the disciplinary appeal tribunals. The applicants also referred to the statements taken by the investigating judge from Mr. B on 5 December 1994. The applicant argued that his client should have been free to conclude that he had been subjected to pressure, and disciplinary appeal tribunal decided that the disciplinary counsel and an advocate was out to obtain evidence and avoid unsupported statements before making a claim. Relevant domestic law and practice. Here is the section 46. I haven't enough time, so I can't read it for you. If a friendly settlement cannot be reached, the matter is referred to the disciplinary council by the dean of bar associations, either at the request of the complaint or ex officio, according to section 46. Advocates should behave in such a way that confidence in the profession or in their own exercise of the profession is not harmed. Alleged violation of Article 10 of the Convention. The applicant alleged a violation of his right to freedom of expression as guaranteed by the Article 10 of the Convention. Everyone has right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by the public authorities and regardless of fortnights. The government argued that the applicant had not been the subject of any formalities, conditions, restrictions, or penalties of a nature to prevent him from, ad- from adequately representing the interests of his client. Let's skip it. In these circumstances, the court is not convinced by the argument of the disciplinary appeal tribunals that the mere fact that the applicant was able to cite information obtained from his client only after making the unplied statement made his action blameworthy. So the court was the side of the applicants and Mr. B. In court's view, therefore, no sufficient reasons have been shown to exist for the interference in question. The restriction on the applicant's right to freedom of expression, therefore, fails to answer any pressing social needs. For these reasons, the court unanimously holds that there has been a violation of Article 10 of the Convention. So thanks for listening to my presentation.